Hello, hi. Today I want to do a recording to discussing the doctrine of consideration and whether or not does it still serve any useful function today in the area of determining enforceability of agreements. The current law today requires for a contract to be enforceable only if there was consideration. And consideration has been defined by judges, and for example, in this famous case of Curry and Misa, to be a valuable benefit, right, or interest that goes to one party, and for the other party to suffer some loss or detriment. And we describe this to be the benefit-detriment analysis or definition for consideration. In other words, consideration can be explained as when one party gives to the other a benefit, and accordingly, he suffers a detriment by the giving of the benefit to that party. And so that's how we understand or define what is consideration, and where the moment there is such benefit-detriment in place, then that agreement can be said to be enforceable. And so if there's a breach of that agreement, then the promisee will be able to sue the other party for a breach of agreement. But the promisee will argue that he has given a benefit to the other party, he has suffered a detriment, and therefore there's consideration provided for the agreement, and so upon breach, he can sue on that agreement. We will regard this agreement to be enforceable because there is benefit-detriment, because there is consideration. However, is such an approach today still one that is desirable? And is the doctrine of consideration still justifiable in today's modern contract law? Because I will argue and show that we have recent developments to contract law where perhaps we may no longer need to depend on this traditional old doctrine of consideration to determine enforceability of agreements. For us to understand this, I would like us to go back in time to examine how it was in the past as to this area of enforceability of agreements. And so if you were to look at this timeline, you would note that even before consideration, we had this era or a system of laws that would recognize the enforceability of agreements based on certain formalities being satisfied. And that is, if this was a contract that was in writing, that carried a seal of the party making the agreement, then this would be what the court would recognize to be an enforceable or to be a legal document that they would uphold in court. And so this was something very formal, that you must be in writing, it must be with a seal. Now, no doubt that seal was then later replaced with a signature. But still, you can imagine how this is very formal. There must be a document in writing and sealed or signed. But that was how it was in the past. But precisely, that the courts then recognized over some time that this was too formal and would not be able to accommodate or allow for enforceability of oral agreements. And also don't forget that in the times past, not everyone was educated or literate. There are many people who can't read or write or sign their names. So how then do we allow for these people to make contracts for the courts to uphold or to deem it to be enforceable? And so the courts then developed something to replace this formality. And that was the doctrine of consideration. What I explained earlier on is that the moment that one has given to the other party consideration, a benefit, and he suffers a detriment, then that agreement shall be enforceable. Yes, this is a good doctrine, because this will clearly show that this agreement is one that the parties would have intended to be enforceable because they've given to each other benefits or detriments. However, what has happened since is that today we have now a more fuller developed doctrine of intention that has taken place since consideration was developed. This doctrine of intention to create a legal relationship, or ITCLR. And if you were to look at the cases that laid down the doctrine of intention, these were mainly cases decided in the 20th century, whereas consideration would have been established already by the 16th, 17th century. And what I'm trying to argue is that because of this later development in contract law, the development and recognition of the doctrine of intention, that perhaps this is far more effective to determine the enforceability of agreements, where the question we should be asking is whether or not is this an agreement for which the parties intended to be bound, intended to be of legal consequence. And if the answer is yes, then therefore this agreement should be enforceable, regardless of whether or not there is any consideration. In other words, I'm submitting or arguing that today, because of the doctrine of intention, we no longer need a rigid application of the doctrine of consideration, and that agreements can be enforceable provided that there is intention. In fact, there is also this later or further development to contract law in the 20th century, where we have cases on the doctrine of economic duress, where this doctrine states that if agreements are made under duress, then the agreement is not enforceable. But if the agreement was without any economic duress, then the agreement should be enforceable. Because if the agreement is made without duress, then this shows that this was an agreement made by the parties freely and willingly intending to creating legal relationship, and accordingly, that agreement should be enforced. And so what we are seeing now is that these two recent developments to contract law, one, the doctrine of intention, and two, the doctrine of economic duress, both combined can act to determine the enforceability of agreements. We no longer need to ask or to examine or to literally rigidly hold on to looking for benefit detriment. Whether there is benefit or detriment is secondary or perhaps no longer even important. So long as this was an agreement where the parties intended to be bound and there was no economic duress, then this agreement should be enforceable. So this would be a thought that you want to have to understanding how recent developments to contract law perhaps may have made the doctrine of consideration outdated or redundant. In fact, we do see many recent cases taking such an approach. For example, the case of Williams and Rolfe brothers was such a case. Now, the case of Williams and Rolfe is a famous case that students will study of a case laying down the doctrine of practical benefit and how practical benefit is adequate, sufficient consideration. But if you were to examine the speeches of the judges in the case, in particular Lord Justice Russell, you will understand why the judges recognize practical benefit as consideration. And so I refer you to the speech or the judgment given by Lord Justice Russell, and he says this. He says that in the late 19th century, 20th century, one should not be rigid with holding on to the doctrine of consideration, as was found in the case of Stickermarriott. In other words, he is advocating for a liberal approach. And he says that the court should be more ready, the court should be more willing to find consideration so as to give effect to the party's intention, and where the finding of consideration reflects the true intention of the parties. And so very clearly, if you look at the judgment by Lord Justice Russell, he is giving emphasis not on benefit detriment, but on intention, and that the finding of consideration should reflect the intention of the parties. Another case that would arrive to a similar position would be the case of MWB and Rock Advertising. But the Court of Appeal in 2017, where the court has confirmed that practical benefit is sufficient consideration, even in the area of part payment of debt. Now, for many years, we have old cases like Folks and Beer, Piano's Rule, where these old cases have confirmed that practical benefit is not sufficient consideration and that part payment of debt will never discharge the full debt. Because if you owe money, you must pay the full money, and even if there was an agreement to receive lesser, an agreement to take part payment, that agreement would not be enforceable. This being the cases of Folks and Beer and Piano's Rule. But in 2017, in 2018, the case of MWB has today confirmed that practical benefit can be sufficient consideration and that an agreement to take lesser can be enforceable. This clearly is an endorsement of practical benefit in the case of Williams and Duffy Brothers, as well as a further confirmation of the approach by the judges in not being rigid or literal to looking for the traditional consideration, benefit detriment, but rather in wanting to recognize the enforceability of agreements based on the intention of the parties. That if the parties intended to be bound, they intend to take lesser payment, they intend for a payment of lesser sum of a debt to discharge the full debt, and if this reflects their intention to be legal, and this was without any economic duress, then that agreement should be enforceable. However, MWB went to the Supreme Court and the case was overturned. However, it was overturned by the Supreme Court in 2018 on different grounds. Rather, it was not on the grounds of practical benefit or on consideration. In other words, the views of the Court of Appeal in the case of MWB today is still perhaps a plausible view that one could adopt to argue that practical benefit, intention to be bound, and absence of duress may be sufficient to allow for agreements to be enforceable. So today, we want to be a bit more critical to look at recent judicial pronouncements, look at cases where we have seen judges being more liberal in the approach of consideration. And so perhaps there may not be a need for us to still be rigid to applying the traditional benefit detriment consideration. I want to end this recording or lecture by quoting Professor McKendrick. And he writes, and he comments, that today, if English law on contract were to be rewritten, his view is that contract law in England would be rewritten without the requirement of consideration. So give it some thought and consider. Be critical and to ask, do we really need the traditional doctrine of consideration? Could it be replaced perhaps with something else? Why can't agreements be enforceable even without benefit detriment if there was intention to be bound? So with this, I end this lecture. Thank you for listening.